Buenas tardes, bienvenidas, bienvenidos al tercer encuentro de diálogos de Derecho Internacional en la Universidad Torcuato de Itera. Mi nombre es Alejandro Chetman, es un placer y un privilegio enorme recibir al profesor Nico Krisch. Antes de presentar a Nico y escuchar su presentación, quería simplemente aclarar cómo va a ser la mecánica del encuentro. Nico va a hablar por unos 25 o 30 minutos y vamos a recibir preguntas por chat durante toda la presentación. Así que todas las preguntas que tengan o que vayan surgiendo pueden ir escribiéndolas durante la presentación. Nico entiende perfecto español, así que si alguno o alguna prefiere hacer las preguntas en castellano, no hay ningún problema. Ahora voy a virar al inglés para seguir la presentación. So welcome once again. It's a real pleasure to have Nico with us today here at ITELA. Nico Krisch is Professor of International Law at the Graduate Institute of International and Development Studies in Geneva. He has published extensively on international law and international relations. His book, Beyond Constitutionalism, published by Oxford University Press, was awarded the Certificate of Merit of the American Society of International Law. In 2019, he was awarded the inaugural Max Planck Cambridge Prize as probably the most interesting scholar in international law today. He leads an ERC, European Research Council project on stability and change in the international legal order, which I think is part of the framework of the paper he's going to present today. In short, I think he's one of the most interesting voices working in the intersection of international law and international relations today in the world. He's also a mentor and a friend, and we are really thrilled to have you here, Nico. I think he's going to talk about stasis and change in international law or international legal order. Nico, thanks for coming. The floor is yours. We can't hear you yet.
Vale.
There you go.
Vale. Bueno, entonces muchas gracias, Alejandro, para la introducción y para la invitación, que es un placer para mí poder estar con ustedes, pero una lástima que no puedo estar en Buenos Aires para el momento, pero bueno, un otro día esperamos que podamos volver a lo normal. Pero bueno, ahora cambio en inglés, creo que es mejor y todos me entienden mejor, creo así. Yeah, so thanks a lot. As Alejandro has already said, what I'd like to do today is talk about an issue that is animating a project of mine, a project on change and stability in the international legal order that I'm conducting with a team of 4 others, PhD students and a postdoc, in the context of a European Research Council funded initiative. We're trying to think about change in international law, and some of the inspiration of that comes from, say, maybe a broader historical trajectory of international law, a broader historical focus. Now, what do I mean by this? What's the problem we talk about? Maybe it's best to start for this with Herr Lauterpacht, because as Marty Koskinen has told us, it's always good to start with Lauterpacht. Now, Lauterpacht was very engaged, and you can see this in his 1933 book on the function of international law in the international community. He was very concerned about the question of change in international law, and there was a reflection of a very widespread engagement of scholars and thinkers and practitioners with questions of change and stability in the period after the Second World War, especially in the 1930s, which was driven by the perception and the realization that the treaties, especially, and also other legal norms that had emerged over time, were maybe not fitting anymore to the environment that had now changed. That was especially for treaties imposed by force after the First World War and in previous times, but also more broadly. And that because power structures had changed, the constellation of the international order had changed, these old treaties and rules and customary rules were no longer fitting, and people were looking for ways to change that, but they found that international law was a very rigid structure that didn't easily allow for change. Now, this had been realized before, and there was a clause in the Covenant of the League of Nations, Article 19, which addressed the question of peaceful change head on. And it was seen as a very significant move to make that, but it only allowed the Assembly of the League to give some advice on how outdated treaties and other rules could be adjusted. So it wasn't a particularly powerful or forceful provision. And many commentators at the time, John Fisher Williams, for example, was one of the most well-known ones, lamented that fact and said, well, we need to move to a structure where we have a legislature that can actually lead a process of adaptation in a way that isn't possible in current structures. Now, Lauterpacht came into that debate, and the whole fourth part of his 1933 book is devoted to the question of change. He came to that with a certain skepticism. When you read that, kind of much of what he writes is a response to that notion that international law is too rigid, because he says, well, sort of maybe kind of the emphasis on change is really exaggerated, that it underestimates certain abilities of international law to actually change. There are other forms of change than legislative action in the international order. And he focused in particular on the judiciary and doctrinal structures that would have allowed judicial actors, especially the permanent court at the time, to effect change even though there may be no legislature. The clausula rebus sextantibus was one of the main foci of his work on those issues, and the possibilities and limitations that it imposed. But he also said, well, generally, we shouldn't think that international law has a particular problem of change, because it is a structure that really is only dealing with interstate relations. And in these interstate relations, typically the problems of change are not as pressing as they are in domestic settings. And so he said, and I quote, that only when the political organization of the international community has undergone a fundamental change so as to regulate in detail the life of its individual members in its internal aspects, only then will it be possible to speak of a constant flux of changes necessitating legislative remedies. So his point was really kind of, let's not overstate that need for change. International law is different than normal law, and we don't really need a legislature to deal with the necessary adaptations. Now, however, one might see that in the historical context in which he stood, and many people criticized him for that position. Obviously, international law today has changed significantly, and if at the time it may not have dealt with the life of its individual members, states in its internal aspects, as he said. Today, that's obviously very different. Now, if we think of the trajectory of international law from an international law of coexistence to one of cooperation to one of governance, let's say, it is clear that in many areas of international law, and we just think of trade, investment, human rights, and the like, international law is now very intimately linked to domestic affairs, and therefore the pressure on its ability to adapt has risen tremendously, and obviously kind of the need to solve problems of a transboundary nature that may not have been as visible at the time, environmental and otherwise, has also increased significantly. So we'd expect really that this question of change and stability would be at the forefront of what people working on international law are thinking about and writing about. But then there's actually precious little that takes that question head on. Maybe there's some, so of course there's limited engagements. You can see this throughout the Cold War. Obviously, there kind of people have written about that. Even if you look at one of the most prominent accounts that's kind of takes that issue head on, Joseph Weiler and Antonio Cacesa's book, 1988, on change and stability in international lawmaking, which seems to really kind of tackle that. What it does really is kind of rehearse much of the engagement with doctrinal structures, especially kind of general principles and how they can allow for kind of broader or less broad interpretations, without really kind of getting to the question of change very directly, except, and that's probably the major exception that was present throughout the 1970s and 1980s especially, the question of to what extent UN General Assembly resolutions could actually be drivers of change and replace the missing legislative mechanism in international law. As you know, kind of let them kind of fail because of the opposition of Western states in particular, as against the push by developing countries to establish a mechanism that would have allowed for change in a more direct way. Now you can see kind of a similar disengagement with questions of change in the work of the International Law Commission. If you only look at these recent projects that you would have hoped would take on that question pretty directly, customary international law and subsequent practice to treaties, which are both very directly about change, what they do really is not to think about change as a necessary and possibly kind of desirable form or kind of aspect of international law, but they really stick with a traditional voluntarist framework, state voluntarist framework of international law, which, if taken seriously, leads to that very rigid structure of international law that the interwar theorists had already highlighted. Right? If you need consent of all states in order for a rule to change, or something close to consent, of course, change is very rare to happen with the diversity and contestation that characterizes the international order. The problems of collective action that beset it, it erects a threshold that is just far too high for change to be effective. But at the same time, despite that doctrinal frame and the general kind of received wisdom about how international law changes in its minor ways, we actually see a lot of change happening in international law all the time. And a lot of change happening that doesn't seem to really fit well with that structure of consent-based lawmaking. So how to make sense of that potential tension, that is, in essence, kind of, or at least one of the interests that I have with this project on change and stability that I'm going to talk a little bit more about. It really tries to tackle the question of change and stability in the first place from an analytical, empirical perspective, not so much a normative one, although that is also kind of an element of it. And I think there's, and it's particularly visible in the work of the ILC, there's a problem that lawyers often entangle the analytical and the normative to such an extent that one actually doesn't really know what is going on when they make an argument. There's a typical art, you can say, of the lawyer, but it often kind of blurs a bit the ability to understand the processes as they emerge. So what I try to do is I try to take a step back, build on work that has already been done, especially by international relations scholars, on questions of international legal change. And I think especially here about the work of Deal and Koo or Wayne Sandholz, probably the most prominent general accounts. Others have made contributions to that, Ingo Fenske, Pierre Verdier and Eric Wöthen, for example, Monika Hakimi, who you had in the series just a couple of weeks ago, who has recently worked on customs. So there's obviously quite a few people who have tried to tackle bits and pieces, and we're trying to draw a broader picture together that might help us understand how international law changes beyond the doctrinal abstractions that we are accustomed with. Now, in order to get closer to the problematique here, let me first introduce two cases that help us understand how international law changes and maybe give us a certain taste of the variety of change processes that characterize international law. Now, the first vignette is one on war crimes in internal armed conflict. By now, I think we've in a position where we mostly assume that war crimes, at least certain crimes of war, can be committed in internal armed conflict, and there's individual criminal responsibility for those. But if you look at the literature in and around 1990, you will find, well, that wasn't really the case. People thought, well, that was maybe wishful thinking, but wasn't established because criminal responsibility, especially in the Geneva Conventions and the protocols, was reserved to crimes committed in international armed conflicts. Now this changed, and it changed very rapidly when the Bosnian and Rwandan conflicts emerged. Bosnia initially understood to be an international armed conflict, Rwanda obviously an internal one. The Security Council resolutions that established both the ICTY and the ICTR in this context gave them jurisdiction over the crimes committed without specifying more of that, although the ICTR statute made the step, and the rather surprising step to say, well, yeah, indeed, the ICTR has competence to deal with violations of Common Article 3 of the Geneva Conventions. And the step that then kind of made international law roll further than the statute of the ICTR was the ICTY's decision in the Tadic interlocutory appeal in 1995 concerning the Yugoslav war, but really abstracting from the question of whether it was an internal or international armed conflict and saying, well, regardless of whether that's internal or international, we can conclude on the basis of customary law that there is individual criminal responsibility for crimes, certain crimes based on the laws and customs of war in internal armed conflicts as well. Now, that meant, and especially the realignment of much of the literature and most observers really after that, meant that within just a few years, the received wisdom about what customary international law was when it came to criminal responsibility for non-international armed conflicts had changed rapidly, and that was somewhat consolidated further with the Rome Statute, and that happened even though in the Rome negotiations, in and around the Rome negotiations, various countries and important countries like China and India had significant reservations about that. But later on, very few questions were asked about whether international law changed. It was just pretty widely, kind of almost universally accepted that indeed that kind of responsibility is now the state of the law. So one quick movement really of international law that didn't go through the normal steps, but nevertheless kind of changed a very substantial aspect of the international legal order. The second vignette is more human rights oriented. It concerns the obligation to protect women from especially domestic violence from them. One thing that in, say, 1980 was not an issue, was seen as a private affair, not really concerning international law that much, becoming increasingly visible as a political concern throughout the 1980s, and was then increasingly framed as a human rights violation. And the CEDAW Committee's general recommendation in 1989 was the one that really kind of got the ball rolling in this context. That was later strengthened by a 1993 UN General Assembly declaration, a special rapporteur on the issue, CEDAW committee recommendations going further than this original one, even going so far as to see that obligation as part of customary international law. And meanwhile, the issue was taken up also in regional contexts. The 2003 Protocol to the African Charter, the 2009 Istanbul Convention in Europe, which has recently become more contested than it was for some time, and human rights courts and bodies, sort of starting in 2001 with the Inter-American Court, 2009 the European Court, 2011 the African Commission, that all found that there was a positive obligation of states to protect women from domestic violence, leading to a state where today it is widely accepted that this obligation exists, and people hardly contest that anymore. Now there's a bit different process, obviously, much more gradual, step-by-step process than the one that I've recounted in terms of the war crimes example. And nevertheless, we have one drawn-out, multi-sided process in which states and the typical mode of states lawmaking is largely absent. And courts come in, but only to a limited extent. So we have a certain legislative process, but one that is much more messy, one can say, and nevertheless significant effect over a 20-year period. All right, so these just as two examples of what we can think about when we think of cases of change in the international order, and we can take many more. And what we do in the project is we try to build a whole since a database or kind of a set of case studies through which we try to build a broader picture of change. Now, what can these and these other cases teach us really about change in international law? And I want to essentially use them here to deal with three, say, standard assumptions in the literature, both on the international relations and on the international law side, and briefly talk about kind of how these are affected. Now, these guiding assumptions in the literature, the first one would be that international law is typically treated as one whole that we can theorize together. The second, you can say, is that states in these processes of international legal norm change are at the core and are the main drivers. And thirdly, the change typically happens in a relatively sudden fashion, punctuated by punctuating different longer-term stable phases. Now I'm going to talk more about kind of where this comes from in the literature, but let me just say a few things of how those cases can make us see these points differently. Now, the first and rather obvious conclusion to be drawn from there is that there is not one international law or one way in which international law changes, but many. And that is a diversity and variation that we can see across issue areas and institutional contexts. How international law changes in European human rights law is entirely different from how it changes in investment law or from how it changes in the law of state immunity, even though maybe some of the discursive structures may be the same, but the actors and practices that lead to change are radically different. And that make it possible that in some areas, international law changes rather quickly and smoothly. In others, the change takes place slowly and over a long period of time. Now we can discuss to what extent that means we should treat international law as one or not one. That's a question of aesthetic taste, I would say. But certainly we need to be really aware of the significant differences in lawmaking processes in the different areas, and we need to theorize them separately in order to come to a broader picture of what international law is. The second point is that at the core of much of the variation, or at least what seems to be at the core of much of the variation that we see across institutional contexts and issue areas, is the structure of authority that characterizes a given field. Now, when I talk about authority, that points us to something that is maybe less formal and legal and more situated in a social, societal realm. Because authority, if we theorize it, is not something that is pre-existing and granted by mandates necessarily, but is typically endogenously produced. It is the recognition of an actor as one that can induce deference in others. And that recognition is a societal recognition that makes others withhold their judgment or suspend their judgment for at least in certain boundaries and follow the judgment of someone else. That's a typical form of authority in law. Now, in most domestic contexts that we're talking about, such authority in legal orders is pretty clear and consolidated, mostly centered around legislatures and courts, with potentially a somewhat unclear boundary between them, but that shouldn't concern us here. In international law, obviously, it's a much more complex picture. It's pretty clear that there's authority among states acting together, as they've clearly recognized authority. But in the cases that we've seen here, we really haven't seen states acting together in the way that is typically imagined. Rather, we've seen certain groups of states working together with non-state actors, institutions and the like, in order to come over time to a changed picture of international law. So if you want to understand kind of what authorities are there in international law, we have to draw a wider net. And what we do in the project is we identify 5, say, ideal typical pathways that allow us to structure the inquiry to an extent. One is the statist one. It has to do with the states acting collectively. Second would be a multilateral one, states acting within multilateral settings through bodies of international organizations in particular. The third, a more organizational one, where we see international organizations through their secretariats, bureaucracy, expert bodies acting. A fourth, that is judicial in nature. And a fifth, that has to do with private authority. Think about the ICRC, for example, being very central to change processes in international humanitarian law, but a private body, essentially, and we can think of others in areas ranging from trade law to human rights law. Now, in examples we've given, and you can think of any kind of other examples, these 5 pathways tend to be all present, or kind of some more present than others, and they're also co-present. Typically, we don't see just one pathway on which change travels, but instead we see various ones. And we also don't necessarily see that there's just a court, but change processes depend very much on the extent to which a given court occupies a central position in a particular area that it has been recognized as a focal actor. That points us to the fact that authority in each of these fields is socially produced by actors, and maybe kind of practice-oriented Bourdieusian frame might help us best to understand that, but I'm not going to talk more about that here, just to point to the fact that if we want to understand how international law changes, we have to get to these authority granting processes somewhere and have to be sensitive to the authority that certain actors are being granted within the social setting that a particular field of international law generates. A second point that these cases can illuminate for us is different paces of change, and especially the contrast between more sudden and more gradual change. As I said, there's a widespread assumption that change in international law tends to happen rather suddenly. Deal and coup, for example, talk a lot about punctuated equilibria, largely inspired by the image of treaty change, right? Sort of you have long negotiations, suddenly a treaty comes around, changes the law, and then we have a longer phase of stability because treaties are difficult to negotiate. And the case that we had around the ICTY is probably a similar one, relatively quick change pushed forward by a particular focal actor and in a particular crisis situation that allowed that change to happen. But many other cases, and the violence against women case is possibly one among them, are not like that, and we see much more gradual forms of change. And really forms in which authority gets accumulated over time. We don't have a single actor making a statement and bringing about change, or a single site, single event through which that happens. But often we see kind of small beginnings, then growing over time, initially kind of invoking more marginal authorities like the CEDAW committee, that then kind of provide a stepping stone for actors to move to more central authorities, to make their case and become heard and generate authority there. So whether that can happen in this way and in which way it can happen very much depends on the availability of actors, authorities, and institutions in a given field, whether you have that diversity of institutions that you might have, say, in the human rights field, or whether you are in a field where you have a much more focal actor with a higher threshold for access, say the WTO, for example, in which maybe things wouldn't happen in the same way as in the human rights field. We typically see sequences of destabilization, shifts, and then restabilization in most of those processes, but how these are structured, it very much depends on the institutional and authority structure in the given field. Now that brings us to the last point, and kind of I should soon stop so we have some time for discussion and conversation on this. It concerns the varied role of states. Now, states really have, and I think we can structure this as four different roles in these processes. Okay, we typically see them as drivers of change in international law. But here, in many of the cases that we come across, they take pretty different roles. One is as co-authors, right? They appear as authors alongside others, for example, expert bodies that play a significant role. Sometimes they appear as mere bystanders. Somebody else is doing the work, the ICRC, for example, the ICTY, the WTO appellate body. And states may stand on the sidelines and simply let change happen. Sometimes they appear more as spoilers. Somebody else is doing the work, but at some point states come in and say, no way. Right? You can think of the IHL example of direct participation in hostilities, which was a largely expert-driven process, but at some point states came in and said, well, no, not like this. We're against it, or at least some states did so. You can think of the WTO in a similar way, where the appellate body for long used a gaping hole that states had left it to develop world trade law forward. And at some point, the US said, well, no way, and we're not going to deal with that anymore. We're not simply protesting because that doesn't seem to have changed anything. We really have to shut down this body in order to reorient it. So in that sense, kind of a spoiler role. Now we could think about what these roles depend on. Much, of course, depends on the ability of states to act collectively, which will have to do with the diversity of positions, the discord or concord in the international society. Also the degree of salience and the motivation of states to actually come in and drive processes. Much of the variation will depend, as I said before, on authority structures. Some of it will depend on discursive openings. Is there a crisis? Is there an urgent need to change something? Which probably will lower the threshold for other actors than states to come in and make proposals that are then picked up as in, say, cyber war, cybersecurity contexts today, something where real need exists. States may be able to come in and push against that, but they might not always be in a position to do that. And even powerful states sometimes are unable to prevent change from happening unless they can create a broader alliance that might derail change. Think, for example, of the business and human rights context, where Western states were able to derail the consolidation of human rights obligations of non-state actors in the 2003 draft norms, push them onto another track, largely kind of a soft law track. That is now kind of somewhat being resurrected again through the treaty process, but for a long time was on another track than the international law track. All right, I leave it at that. These are really not definite conclusions, but rather observations and attempts at drawing on empirical evidence to help us develop an instrumentarium through which we can structure a much better and much more fine-grained understanding of how change in international law happens. The basis really for a more socio-legal account of how those change processes occur, paying attention to actors and institutions rather than doctrinal abstractions. One of the key results, obviously, is that international law is much more flexible than it is typically assumed, and then the rigid notion of international law suggests, but that there's significant variation in rigidity across the different areas and institutional contexts of international law, and that sometimes these are still not very flexible, as the example of business and human rights that I just mentioned suggests. Right? Often international law actually gives possibilities, veto rights to actors that make it difficult to drive norm change through international law, and then sometimes it goes into other fora. Now, if we go back to Hersch-Lauterpacht's question and Fisher-Williams and others' questions of the interwar period, do we really have a problem with change in international law? The answer might be, well, we may have, we may not have, but actually we have maybe many problems, and some graver than others. And it's only really slowly that we understand what these problems are, how difficult change really is in different contexts, and what the limitations and possibilities are for actors to drive change. Now, once we've figured that out, then we can start thinking of potential remedies, and remedies, I think, that will go probably much further than the clausula rebus consideration, but will make us kind of become much more attentive to institutional structures, authority structures, and a recognition of how these work and how these can potentially be expanded or limited, which will then be the basis of a much more normative exploration. But that's not something that I'm going to do today. I just wanted to kind of give us a bit of the analytical picture, you can say. And I hope that this strikes a chord with some of you who kind of work in different areas of international law and have for long thought, well, so the way that doctrine presents international law isn't really helpful, and we need to take a step back and reorient ourselves in order to understand how international law really works. Thank you very much.
Thank you so much, Nico. That was really, really interesting. I have a few questions lined up. So the rest of you who want to make questions, please go through the chat. So the first question I have sort of follows what you were talking about, the role of the state, but in a different, looking at different actor, which is what is the role you see of civil society in achieving this change of in international law?
Yeah, really important question, and one that we're going to be trying to tackle largely kind of through theorizing a bit more who the change agents are in different change processes. And often you'll find civil society at the core of change process, right? The human rights example that I gave, violence against women, obviously goes back to civil society engagement, trying to trigger authoritative statements in a UN context, in that case, and link up with especially the CEDAW context and the institutions around CEDAW. So civil society obviously is an important sort of change agent in that. What it is doing less and is less able to do is to act as an authority, right? It has to itself trigger authorities, kind of move onto one of these pathways or multiple pathways that I've suggested. And kind of try to get authoritative statements from those in order to foster their cause. But they're not going to be able to, at least typically, act as authoritative actors themselves. Now, that's not always the case. Right? There's some areas where actors like Human Rights Watch or Amnesty International, say, have a certain gravity. And when they make a statement about the state of human rights law, they are actors and their authorities in their own right. Not the most decisive ones potentially, but at least they come into the broader conversation. In other areas, we will have less of that.
Excellent. A somewhat related question. So, do you think there's any strategic insight in the kind of research you're pushing through here? In the sense of giving any sort of insights to states, organizations, international bodies about how to effect change? Is there anything like that you can draw from what you're doing?
Yeah, probably yes. I mean, so we haven't thought of it in this way, but probably one could do kind of once we're a bit further down the line, right? A bit of a bullet point presentation, kind of say, well, look, sort of, if you want to effect change, right? Sort of. That's what you do, and I find that's actually rather interesting, because one thing that we've been trying to do is trying to think a bit more systematically about how actors choose the pathways that they go onto. So what drives actors' choices, and it seems to be typically kind of a combination of two factors. One is the likely receptiveness of the particular pathway of an authority that you want to go to. Kind of, are they going to take up your cause? And the second is the weight that they have, right? And it's somewhat a combination of the two. Kind of typically, you'll find authorities that you kind of first go to that might be more marginal, as in the CEDAW example that I've just given. The CEDAW committee being relatively marginal, kind of at the time not really even in the human rights community, somewhat a strange fringe actor, but obviously receptive to the cause of women's rights NGOs in a very different way than the International Law Commission would have been, right? Had you gone in the 1980s to the International Law Commission and said, also, please kind of do a project on positive obligations on domestic violence, I'm sure kind of the types on the International Law Commission would have just laughed and shrugged and said, well, that's not something for us, right? It's obviously kind of not our business. So the receptiveness was important, but over time then especially, kind of you want to build up the authority and you want to go to actors that may give greater weight to the statement, so you have to move closer to the center. Now sometimes, of course, and that depends very much on the institutional structure, actors will not find these intermediary institutions, but they will try to engage others, for example, in statements, right? So to get change going. So expert groups, for example, assembled on a certain issue may serve a function to move away from the merely individual position to something that has somewhat more gravitas and may be picked up later by a court or some other body. Right? And in fact, it's really interesting because if you read sort of literature on strategic litigation, for example, right, you'll find lots of those considerations spelled out there where people say, well, so, okay, so that's how you pick fora, you kind of try to work out kind of who's going to listen to you, but at the same time you want to be heard by a broader audience as well. But sometimes that's a process that is a step-by-step process. So there are lots of linkages there. Actually, they're very interesting to explore.
Excellent. And going back to, I think, a previous issue, what would you say is the role of legitimacy in changing international law? You were referring just now to expert groups and the authority of expert groups. You talked about the Tadic decision, and that was clearly, to some significant extent, developed through the sort of quality or the high prestige of the writers of that decisions, who were very, very elite and prestigious international lawyers. And the question is democracy providing legitimacy to support change in any way in international law at all?
Now, this is a kind of a tricky and broad question, really. Thanks. So, I mean, of course, there are two elements. One is kind of the more normative, and one is a more sociological take on legitimacy. And it's probably good to keep these somewhat apart. Kind of as an analytical matter, obviously, kind of democracy comes into international law making and processes of international legal change in a somewhat indirect and mediated way, largely through democratic processes in the domestic setting, at least in states that have such more or less democratic processes. It comes into an extent, obviously, in kind of the, or at least depending on the kind of democratic theory you use, right, in the degree of transparency and openness of multilateral processes, right? If you think of international environmental lawmaking and the sheer number of NGOs participating, if you have a kind of pluralist sort of democratic approach to that, you might think, well, that's at least an element of democratization of lawmaking processes away from states to a broader engagement of civil society in there. Now, that is not, it's not necessarily driving, I think, where the action is, although processes of delegitimation sometimes can lead to new actors and authorities gaining greater weight than others. So certainly, kind of in the environmental context, it is very difficult today to come to bigger lawmaking ventures without engaging civil society. Right? It is almost unthinkable. It would be probably ineffective because too many actors would say, well, so it's impossible, right? You don't bring the expertise and you don't bring representativeness in. In other areas, that's entirely possible, right? In security matters, you don't have that kind of expectation existing, and so states can pretty much do what they want in those contexts. Normatively, obviously, the question is different, and one very much depends on the normative take one has. Kind of most of the processes that we're talking about in international lawmaking, I think, are very far from democratically legitimate, and they can always only approximate some such legitimacy, kind of, but at a certain remove, which is partly simply due to the non-ideal situation of international society, in which we have lots of societies interacting and being interdependent that are not democratically structured, or some of which are democratically structured and others not. Others to do with more simple practical problems of a lack of communicative links and ability to actually properly exchange and deliberate across boundaries in that setting. That would take us far too far to kind of disentangle this kind of theoretically, but I think so. At least there are some pointers how analytically and normatively one could go about that question.
Good, thank you. Pushing you a bit more on the sociological bit. My sense was from your presentation and from reading and studying international law that expertise has a very large role in legitimizing decisions and legitimizing change in international law rather than democratic processes. Except for the mention you made to civil society in international environmental law, I think much of what you describe has to do with the authority of expertise. Would you say that that's a sort of a correct characterization of the view, or not necessarily?
Yeah, it is probably true. There's quite a bit of sort of expertise-based decision-making, and that's something that states that are concerned about a move away from typical statist procedures of lawmaking and interpretation are also kind of alleging. They say, well, so that doesn't have a grounding in the democratic processes of legitimacy that we have domestically, and takes us into some other kind of more output-oriented direction of legitimation. I think it is probably true. It very much depends really on the openings that are there for experts to come in, right? So sometimes when you have particular sort of an area structured by political actors, say the UN Security Council, right? There might not be that much space next to it to affect lawmaking through experts, right? There might be some areas, obviously. In other areas where you don't have collective mechanisms for states to actually set rules and adapt rules to new circumstances, there's going to be a much wider room for experts to do the work. And kind of in the project, we have one paper by a colleague from Queen's University in Canada, Nicolas Lamp, who's kind of tracing how states in international trade lawmaking have essentially withdrawn. They've simply given up on using the more diplomatic, multilateral tools of guiding lawmaking, in part because they thought they couldn't achieve the outcome that they wanted through these processes, and left the room to the WTO appellate body to essentially kind of do the same thing in the direction that it wanted. So there's an interaction going on, and expertise is often second best, I think, but because, and compared to kind of the more, say, sort of statist sort of diplomatic processes, but because these other processes often do not work in an effective way to really kind of form a common position, that space opens up and then other actors can come in.
Excellent, thank you so much. And a separate question. So where do you see change coming from in international law? Do you see any sort of regional patterns, or certain regions pushing for change in certain areas, or certain institutions pushing for change in certain areas? Is there a difference, or is there a difference in terms of who is pushing for change and who is pushing for stability, in a sense? Yeah, so
it's a good question. I don't know if one can give a kind of general answer to that, and it's probably that kind of we have different change agents in trade law than we have in human rights law, and then also on different issues in human rights or the like. In that sense, I mean, I think that's not an easy general question to answer, and especially regionally, we see kind of great variation. Now, probably there is, as typically, kind of there's greater ability of well-resourced of actors from relatively well-resourced countries, richer countries of the global north, being able to effect change, and that's true for civil society actors just as well as for state actors, just because of the resources, the expertise, the possibilities that they have to gather people, kind of produce statements and the like. So that's probably something you see. At the same time, of course, you have processes of contestation from other areas that are relatively strong. Think of the backlash of certain Latin American countries against international investment law that has at least shaken up the field to some extent and produced in part a need to reform the bilateral investment treaty system, the institutions, the arbitration, and the broader processes around them. So there you can see a change agent, obviously, kind of pushing pretty strongly, possibly really kind of only becoming effective when some of the northern states really kind of jump on the bandwagon, and civil society action becomes strong, as you could see, for example, in the CETA or TTIP context in Europe, where there's a kind of multitude of different actors that kind of have to come together in order for this change to become effective. But it certainly started with greater discontent, I think, in the global south, just obviously because the investment law is so skewed against developing countries.
I have a question. The author of the question says he or she is not sure of the difference or whether the difference is relevant. But do you see any change or any difference in terms of change in an existing rule from the change that involves creating a new rule? Is that something that works differently in the international legal order or not necessarily?
Yeah, really good question, and something we've been struggling with a bit. I mean, there's a whole kind of literature in international relations that is interested in norm emergence, or it's largely theorized norm emergence, really. So you think of the seminal Finnemore and Sicking piece on norm change in international politics. That's largely to do with kind of new norms coming up and being pushed forward and possibly being taken up by a greater number of states and then being internalized by them. So that's often the focus. Now, we've been trying to get our head around whether the dynamics are different in sort of new norms emerging as opposed to old norms being changed. Now, and so just kind of make it short, I'm not really convinced that there's really a seminal, a decisive difference, but where there is a difference is that change from an existing norm can often more easily happen with a lower threshold, say, through analogical reasoning, right? So there's a kind of assumption that, say, norm adjacency, kind of, so if a new norm or a new understanding of a norm is close to an existing norm, you can more easily move into the new direction. Right? So Wayne Sandholz's work, for example, is kind of very much built around those kinds of processes, in which you kind of have a sort of common law type of approach to slowly shifting understandings of rules through actors, and kind of analogical reasoning is important. Kind of that suggests that this would be significantly easier for an existing norm than for creating a norm from scratch for which you don't have that really. Now, whether in practice we can actually see that making such a difference, I'm not fully sure yet, and maybe we don't have enough data to bear that out. The fact is, I think if you have sufficient political momentum in favor of a new norm, you might get it through whether it can latch onto an existing norm or not. Although that depends also kind of in which forum you want to do that, right? So if you want to do it within a court setting, for example, you might have much easier time if you can link to an existing norm. If you are in a more political setting, it might not make such a difference, really. So in that sense, kind of, I think the kinds of discourses around certain institutions and pathways through which you can affect change are obviously different, and they may facilitate sort of gradual adaptation of norms over the creation of new norms in certain kind of more legally driven contexts.
Thanks a lot. That was useful. There are quite a bit of people doing research in international law, and I think we have only 5 more minutes. So the last question I will ask you is about your methodology for this amazing project that you're leading. So how do you model the research for these kind of research questions? I think that would be very useful for several people working or doing research in international law, particularly at the crossroads of international law, some empirical legal research, and international relations.
Yeah, thanks. So now kind of sort of a bit of lab talk. So kind of what we're doing with this, kind of obviously we started off with a few assumptions that we then tested on a few kind of pilot case studies, and we do kind of largely, we go through overall a range of qualitative case studies that we then kind of try to draw together. So initially, kind of we did this in a sort of mix between more deduction from initial hypotheses and induction from the insights that we had from our pilot case studies, in order to build a bit of a framework that allowed us to structure the factors and some guiding conjectures that drive our work, and then use the broader work on case studies in order to illuminate or kind of sort of get us a better understanding to what extent these factors are present in those cases, and to what extent they might be able to explain the outcomes that we can see. Now, there's not a large N study, kind of that's just the kind of qualitative work that we're doing. Doesn't lend itself to kind of having several hundreds of cases kind of being generated, certainly not with the resources that we have. We need a much bigger team for that, and then kind of you have all kinds of follow-on questions of coder reliability and intercoder reliability and all that. But at least they can be suggestive of certain trends and patterns. We've been trying through the selection of case studies to generate a certain spread already. So obviously across issue areas, we're taking 8 issue areas into view, which all come with their own institutional setting. So that generates a variation, at least on the institutional side. We also create some variation across time, sort of trying to get case studies from different periods, not going back to the dark ages of international lawmaking, but really kind of sort of staying in the last 50 years, but trying to kind of understand a bit to what extent change processes happen differently. And it is pretty obvious that the 1990s are a particularly fertile ground for successful change, whereas before and after you see less movement, and it is largely obviously to do with the geopolitical constellation that pertained in this and during this area, right? So roughly kind of trying to first build up a set of conjectures or hypotheses about the factors and processes that drive change and variation in change, and then trying to work these through with this empirical material, which again kind of throws up obviously new ideas that then you can build in, and you try to you adjust your initial hypotheses. The good thing about qualitative work is that you're always able to do that.
Thank you so much, Nico. I think our time is up. We are sharp at 3 p.m. Argentina time, and it's rather late for you in Europe. It's been a real pleasure. I'm sure we're all looking forward to seeing many of the outcomes of this fascinating project. And thank you so much for doing this on behalf of everyone here at Ditela. And for the rest of you, we resume these dialogues in 2 weeks' time on the 11th of November with Dapo Akande. Thank you, Nico. Pleasure.
Yeah. So thanks a lot for having me and asking me all these questions. Enormously helpful, really, for my further thinking on this. And so great to be with you, and hopefully, as I said, sometime in person in Buenos Aires, and likewise. I hope Alejandro will be able to come over to Geneva at some point, and whenever traveling resumes, if it resumes.
Whenever traveling resumes, we certainly look forward to having you here. Thank you so much.
Great. Thank you.
Bye.
Bye.